Hi, my name is Michael Santos. I'm the founder of Prison Professors, and just about every day we like to produce content with hopes of helping people who are navigating challenges through the federal judicial system. And today I want to talk about some of the challenges going on regarding the application of earned time credits. Now, earned time credits were a part of the First Step Act that incentivized people to work toward preparing for success upon release. And people who qualified because they didn't have a disqualifying offense, such as a crime of violence, and they also received either a low or a minimum pattern score, would earn credits that they could apply to their sentence, to advancing their sentence, but also to an earlier transition to home confinement. And this is an important subject matter, but there have been some challenges in the Bureau of Prisons using this auto calculation system that is supposed to calculate earned time credits. I know it's a little bit complicated for people who don't have any experience in the criminal justice system. It's experience for people who are serving time in federal prison. And one of our missions as an advocacy group is to provide as much information as we can to help people learn how to self-advocate. Because once a person gets into the prison system, the access to a defense attorney will be gone, and the person is really going to have to figure out, okay, how do I work my way out of these challenges? How do I look far enough into the future? Well, one thing you can do if you're outside is you could learn a little bit about the habeas corpus petition and what options exist. What do you have to do if the Bureau of Prisons doesn't calculate your sentence length in the appropriate way? And that's the purpose of this video. Now, we create these videos to send not only to people in the community that anybody could access on our website at prisonprofessors.com, or listen to if you're listening on iTunes, if you are, or watch on YouTube if you are doing one of those things. We do hope that you will subscribe, but it's equally important for us to share this message with people who are serving sentences, people who are in prison. We have a distribution channel where we reach hundreds of thousands of people every day. And it's our part of our advocacy effort is trying to help those people learn how to help themselves. That's the motto that you'll see behind all of the companies that I create. And I'm just a person. I'm not a lawyer. I'm somebody who served 26 years in federal prison, but I learned how to navigate it well, and I try to share those strategies with as many people as possible. So yesterday I wrote a rather lengthy article that I use to disseminate to people in prison, because I want, again, to help them learn how to help themselves. But there are people out here who have family members in the system, and so I wanted to publish it on our publish the article on our website as well. You could visit it at Prison Professors. If you can't find it, just go into the search bar and type in 2241, which is the motion we're going to discuss. But let me go ahead and read the article right now, right from our website. And you will notice on the top of the website there is a button that says 2241 post. So if I were to click that button, I would go right over here and I would actually be able to see the post, the actual petition that a person would have to file in federal court. So this is an actual 2241 petition. You can see it's not terribly cumbersome or complicated. You just have to insert some basic information. Even here, it'll specifically say you do not have to cite case law. You can if you want to, but you don't have to. You don't have to submit supporting documentation. You can, but you don't have to. What is important is that this is for a person to understand is this is something the individual can file on his own. Now, in fact, he is the only person that can file it is a person in custody or a lawyer that represents that individual in the specific district. I can't file this on behalf of anybody. I can show you how I would have done it, and that's what I'm trying to do through this article, which I will start reading right now. So let me go ahead and turn back to this section, and I will just go ahead and read the article just as the people in custody are reading. And one of the other reasons that I create these and read these, I'll show you right here, is we sometimes people in prison have a hard time even reading, because our system tends to incarcerate people that do not have access to mentors or leadership or people that can help them. And that's why we produce all of our work also on this kind of low technology. I'll show you on the bigger screen, this low technology of these DVDs. And these DVDs, you can see if you open them up, they're just showing people how to prepare for success, even if they're inside of a prison. And sometimes preparing for success requires a person to learn how to advocate for himself. So let's go ahead and read this article. Part of our company's mission is to provide income opportunities for formerly incarcerated people. That usually works out, but sometimes it does not. Last month, we removed a person from our company because he was full of crap. He misrepresented himself, leading others to believe he could change the past. Our company doesn't stand for that nonsense, as every document in our company shows, and the website shows. Since getting out of prison in 2013, I have built a business around lessons I learned from serving 26 years in prison. I strive to show the strategies that help me get results, hoping that others can use those same strategies. All my work pledges that I will never lie to anyone and that I will never suggest that anyone do anything that I did not personally do. This letter shows the strategies I would have used if I did not get the result I wanted from the rollout of the auto calculation system. First, I would have used diplomacy. If that didn't work, I would take the following steps. For the past week, I have been doing my best to get clarity on why the BOP has not updated sentence computation sheets for all people in federal prison. Many people in federal prisons, halfway houses, and in-home confinement feel frustrated with the Bureau of Prisons because the system did not appropriately calculate their earned time credits. Although the system should have granted their immediate release or advanced their release date, those people continue to serve federal prison terms even though they earned freedom, according to their compliance with the First Step Act. People should be free, but they're still in prison. If you're experiencing problems, it is crucial to self-advocate using the appropriate process. People should know their options. So what options exist? Well, to ensure that no one accuses me of practicing law without a license, I want to be clear that I am not giving legal advice to anyone. I don't have a law degree and have never applied to practice law. I am a person who served 26 years in federal prison. During that time, I learned to self-advocate. I predicate all my work at Prison Professors on helping others understand lessons I learned about the importance of self-advocacy. When striving to overcome systemic errors, many people have the initial instinct to complain, but that rarely works. A person must know what to do. They cannot simply write to a judge seeking relief or hope someone else will resolve the problem. Our company retains subject matter experts who retired from the Bureau of Prisons leadership. Those people cannot solve anyone's problem, but they understand the levers a person can pull in pursuit of relief. Sometimes it works, sometimes it doesn't. From every resource I can find, I try to get answers from insiders about what's going on and how long the BOP will require to fix the problem. Although every person says the BOP is aware of the problem and trying to fix the auto calculation system, I am still trying to get clear answers on how long it will take. So let me just give a little commentary on what we're talking about here, because some people just don't even know what the First Step Act is. Nor do they know what the auto calculation system is, nor do they know what earned time credits are. Well, if a person has a sentence of, let's say, 5 years, that person is going to receive a series of opportunities to advance that date besides just the turning of calendar pages. One of those is called good conduct time. So by statute, the law holds that as long as a person doesn't violate rules and doesn't get charged with losing their statutory good conduct time, also known as GCT, that person will receive 15% off of the sentence. So a 60-month sentence would receive 9 months off the sentence, provided that the person complies with the rules and doesn't get charged with misbehavior. But now there is another component called the earned time credit. Now, the earned time credit is different from good conduct time in that it not only allows for potentially up to 12 months off of the sentence, it also authorizes a person to work toward going to a residential reentry center or home confinement at a much earlier time than is otherwise provided by the system. So again, it's pretty complicated. I have a depth and breadth of information that we publish on Prison Professors to help people see and understand. But if somebody is in custody and they're not getting these credits, there is an appropriate vehicle to to self-advocate. And that's what we will continue reading right now. But first, a person really has to understand the Prison Litigation Reform Act, also known as the PLRA. So to succeed in prison, a person must learn to self-advocate. The BOP does not respond well to lawyers. Further, both legislative actions and judicial decisions make it difficult for people to seek relief by going through the administrative remedy process first. If people don't exhaust the appropriate process, courts may dismiss legitimate claims. The Prison Litigation Reform Act presents many challenges for people seeking relief from a U.S. District Court judge. The PLRA requires people in federal prison to show that they tried to resolve the complaint through the administrative remedy procedure. That cumbersome process begins as follows. Step 1. Write a description of the complaint to a staff member. That is easy. If people believe the BOP isn't adhering to a policy or law, they must write the grievance on a cop-out form. For example, initial notification. I filed this grievance on January the 15th because my release date does not reflect my earned time credits. I meet all the criteria of the First Step Act, and I have participated in this many productive activities over the past this many months. I request that the BOP update my sentence computation sheet to show the earned time credits. That is just how you launch this whole initiative. You just write a really simple, clear explanation of what is the problem. Now, you've got to be very clear that you only say one thing. You don't list a litany of problems. You say one thing. They're not applying my credits appropriately. So that's the first step. Now let's go to the second step. Give staff members 24 hours to respond. If they do not respond within 24 hours, or if they provide a computation sheet that does not accurately reflect the earned time credits, the PLRA requires people to continue. They must build a record that shows they worked through the process to exhaust all available administrative appeals. That means the next step would be to file a BP-9. The person must request a BP-9 from the staff counselor, and the counselor will log the entry into a book. That entry becomes a part of the record. If the counselor is unavailable, then the person should record that the counselor is unavailable and write a letter requesting that the warden treat the letter as a BP-9, request for administrative remedy. For example, and here's a BP-9 example. This is all you write. I file this grievance requesting application of the earned time credits that the BOP should apply to my sentence computation. I attach the initial request I made to staff on, then insert the date. When I requested an updated sentence computation sheet reflecting my earned time credits, I did not receive an updated sentence computation that reflects the earned time credits I have earned, in accordance with the First Step Act and BOP policy number 5410.01. Please provide an updated computation sheet describing why my sentence computation does not reflect time credits I earned in accordance with the First Step Act and policy number 5410.01. And then you want to include a copy of the initial cop-out, the initial form that you submitted. Now, if you want to see an example of what a BP-9 looks like, it's really simple to find. If you go to prisonprofessors.com and you go to the search bar and you type in BP-9 or administrative remedy, you will see that we have an article specifically on administrative remedy process. In fact, I'll try to show that to you on this screen. I don't know if I'll be able to get there given the way that I kind of orchestrated this computer, but I'm going to see. Oh God, I don't want to do that. You're just going to have to, let's just do it this way. You're just going to have to, what was I going to say? You're just going to have to go to the Prison Professors website. Under the top bar of the website, you will see resources. And I encourage you to go to the section that says advocacy, and that's a table of different articles and videos that I created specifically to help people self-advocate, and look for administrative remedy forms. And you will see an article that describes this process. You will also find a button where you can download the forms themselves and just get a feel for it. The more knowledgeable you become about administrative remedy and the Prison Litigation Reform Act, the more confident you're going to be if, God forbid, you have to advocate for yourself. These are lessons that I learned while going through 26 years in prison. They are lessons that anybody going into the system should learn. not because they want to litigate, but because sometimes while you're in federal prison, these complications surface and you're not going to have a lawyer to help you. So that's what being a part of our community is really all about. You get these resources that we provide so that you could learn how to help yourself. And everything we offer is free on our website at Prison Professors. We sell a lot of consulting if it requires time or if it requires advocacy efforts, but if somebody wants to do the work, just visit Prison Professors and you'll get all the information for free. So let's go on. Where was I? I think I gave you the BP9. Let's continue with the next step. So the next step is step number 3, the BP10. The administrative remedy process provides staff members with 20 days to respond. If the staff members do not respond within 20 days or do not provide a satisfactory response, the PLRA, Prison Litigation Reform Act, requires people in prison to file an appeal. People must request the BP10 form from the counselor. If the counselor is unavailable, then the person should record that the counselor is unavailable and write a letter requesting that the regional director treat the letter as a BP10, the Regional Administrative Remedy Appeal. For example, BP10. I appeal the warden's response to my request for administrative remedy. On this date, I filed a notice requesting an accurate sentence computation sheet that shows the earned time credits I earned in accordance with the First Step Act and BOP policy number 5410.01. I did not receive a favorable response and I appealed. The warden did not grant the relief requested. To comply with the Prison Litigation Reform Act, I appealed the BOP's denial to apply earned time credits to my sentence computation and request administrative remedy. Step 4, the BP11. The administrative remedy process provides 30 days for staff members at the regional office to respond. If the staff members do not respond within 30 days or do not provide a satisfactory response, the PLRA requires people in prison to file an appeal to the central office. People must request the BP11 form from the counselor. If the counselor is unavailable, then the person should record that the counselor is unavailable and write on a letter requesting that the central office treat the letter as a BP11, the Central Office Administrative Remedy Appeal. Form BP-11. This is the final appeal. This is what exhausts an administrative remedy, the BP-11. I appeal the regional director's response to my request for administrative remedy. On this date, I filed a notice requesting an accurate sentence computation sheet that shows that earned time credits in accordance with the First Step Act and BOP policy number 5410.01 should apply to my case. I did not receive a favorable response, and I appealed to the warden on this date. The warden did not grant the relief requested. To comply with the Prison Litigation Reform Act on this date, I appealed to the regional director for administrative relief. The BOP continues to deny the application of my earned time credits to my sentence computation, and I request administrative remedy. Now notice that I was somewhat specific in these examples of giving a date that I did something. That's because there are timelines associated with the administrative remedy process. And the BOP will hold a person accountable to all those timelines. Sometimes the BOP doesn't hold itself accountable. It may ask for extensions and so on and so forth. But this is the process. You see, courts have not made it easy for people to litigate. Why? Because judges don't want to be involved in prison management. The only time they'll get involved is if there is a constitutional violation, such as you have a right to earn time credits, Congress authorized the law, but the BOP is not carrying out the law in violation of your rights to due process. That's the reason that you would pursue this path to get a federal judge to consider it. But you can't get a federal judge involved unless you go through the administrative remedy process according to the Prison Litigation Reform Act. Now, there's a lot that you could learn about this act, and I encourage you to continue learning, but I also thought it would be helpful to kind of show you what would a 2241 look if I were in prison. So I'm going to continue reading. So let's see here. So the motion pursuant to 2241. If the central office does not grant relief within 30 days, people can show that they have complied with the PLRA and exhausted their requests for administrative remedy. They should have copies of all previous correspondence regarding the pursuit of administrative remedy. The pursuit of relief under Title 28 U.S.C. 2241 is not as complicated as it sounds. Although I am not a lawyer, while going through 26 years in federal prison, I learned that a person could simply write in a letter format that is appropriately titled so the district court understands the nature of the motion. Now, I never ask anyone to do anything that I didn't do while I served my lengthy sentence. Although the BOP released me in 2013, if I were still in prison and the BOP were not giving me the credits I deserved, I would first exhaust the administrative remedy process as described above. Then I would file a pro se motion under Title 28 U.S.C. Section 2241. Some people may know how to do that, but it's not too complicated. Since only a licensed attorney or a person who is self-advocating can file such a motion, I thought it might be helpful to show how I would have filed. For example, at the top of the letter, on the left side of the page, insert something as follows. Michael Santos, petitioner. I am petitioning the court for intervention versus the warden, who is the respondent. That warden is supposed to respond to this motion. And then beneath the heading, insert the following in bold or in all caps regarding pro se motion under Title 28 U.S.C. Section 2241 for application of First Step Act earned time credits toward a sentence computation. Now, this is a letter motion. I would also encourage you, just so like we said before, I would also encourage you to get the actual motion from the court and go through these steps as shown on the court's actual document. You could just attach this as a letter to kind of put it in narrative form, because you can see they don't give you very much room here. So this is how I would attach a letter that allows you to kind of explain to the court in a narrative format what's going on. So that just write a standard letter to the judge. Dear Judge, I am not an attorney, and I am filing this pro se motion moving this honorable court to order the Bureau of Prisons to apply First Step Act earned time credits to my federal prison sentence. Just a very clear declaratory sentence asking the judge what you want. Then you give him the background. On this date, the President of the United States signed into law the First Step Act, Title 18 U.S.C. Section 3632. The First Step Act grants eligible inmates the ability to earn time credits for successfully participating in and completing approved evidence-based reducing programs or productive activities. My conviction qualifies me to earn the FSA credits. Since entering federal prison on this date to serve a sentence of this many number of months, the record shows that I have avoided disciplinary infractions and participated in evidence-based reduction programs or productive activities as directed by staff members. On several occasions, I requested BOP staff members to apply the credits earned toward my sentence computation. Despite numerous requests, the BOP has not updated my computation sheet to reflect the ETC I earned in accordance with the First Step Act and BOP policy number 5410.01. Pursuant to Title 42 U.S.C. Section 1997E parentheses A, I have complied with the Prison Litigation Reform Act, requiring me to exhaust administrative remedies to resolve this grievance. Petitioner contends that the BOP failed to adhere to the FSA in its imposition of his sentence in two distinct areas. One, the BOP failed to apply 15 days of ETC for every 30 days of confinement, and two, the BOP failed to correctly calculate the FSA and productive activity of EBRR credits toward the remainder of his sentence. Petitioner contends that not applying the correctly calculated FSA earned time credits violates the congressional intent under Title 18 U.S.C. Section 3632 and inflicts irreparable harm by sanctioning him to longer prison term than allowed under Title 18 U.S.C. Section 3553 and Section 3632. Petitioner contends that he made a good faith effort in attempting to resolve those concerns prior to filing in the district court. The movant submitted the following administrative remedy forms. 1. Initial request on that date. BP 9 administrative form on that date. 3. BP 10 on that date. 4. BP 11 on this date. And then the Section 4 time credits, application of time credits toward approved release custody holds. This is what the First Step Act holds. That time credits earned by prisoners who successfully participate in recidivism reduction programs or productive activities and who have been determined to be at minimum risk or low risk for recidivating pursuant to their last two reassessments shall be applied toward time in pre-release custody. The director of the BOP shall transfer prisoners described in this section into pre-release custody, known as supervised release. So for the foregoing reasons, petitioner moves this honorable court to grant immediate habeas corpus release under Title 28, Section 2241, forcing the Bureau of Prisons to apply all earned time credits to the sentence computation and grant immediate release. And then just I, Michael Santos, under penalty of perjury, hereby affirm that all statements given hereof are truthful to the best of my knowledge. I have mailed a certified copy of this motion to the Assistant U.S. Attorney's Office in the district, and I also sent a copy to the clerk of the court. Petitioner requests the clerk to return a stamped copy to the petitioner showing this motion has been filed with this honorable court and showing the appropriate case number for this pro se motion titled 28 U.S.C. 2241. And then respectfully submitted, give that, and then I just kind of show what I would include there. And that is the process. Now, in this example that I gave, I gave a specific example because there are thousands of people in federal prison today in January 2023 that feel as though the BOP is not calculating their earned time credits appropriately. They have a remedy. One of this is to use their diplomacy, but sometimes that diplomacy doesn't work, and they have to use administrative remedy because that's what Congress and different courts have required people to do under the Prison Litigation Reform Act. Then they can take the matter to a court. Now, I am continuing to research to try and help people advocate for themselves by trying to find cases that may help an individual understand if they could pursue in court, even though the Prison Litigation Reform Act is not working. So this is part of the self-advocacy work we do at Prison Professors. I hope that you will support our work by working through all our courses and avoiding problems if you're in prison. But if you're outside listening on iTunes or YouTube or our website, we just hope that you will subscribe to wherever you're getting this information and become a part of our community. We truly believe that every individual going into that system should work hard toward emerging successfully, and sometimes that requires a little bit of elbow grease in learning how to advocate for yourself and then executing a plan. Remember, we want to visualize success, we want to create a plan, we want to put priorities in place and create our tools, tactics, and resources and execute the plan. That's the power that got me through 9,500 days in prison. It's the message that I strive to give to everybody in our community. We believe in you. Thanks.